All right, Chanley Painter giving us the latest. And felony murder. Think about it. Felony murder. That's the top charge here. That's life in prison. That's the same charge that the two guys with the guns and the pickup were charged with, okay? So this is as serious as it gets. And from my perspective, I was surprised on the one hand, but not surprised on the other. Because there's obviously evidence that we haven't seen, which is, all right, we're hearing there's a couple other videos out there. What do those videos show about the moments beforehand, right? Before that video starts rolling that we've seen already that was leaked, what do the videos show of what was taking place beforehand? What was Roddie, Bryan doing? And I guess based on whatever that evidence is, the GBI, Georgia Bureau of Investigation, believes there's enough to charge him with felony murder tonight. Okay, let's break this all down. Bring in our think tank tonight. Big breaking news tonight. Joining us tonight, Marsha Mignon. She is a great criminal defense attorney, former prosecutor in the ATL, which is in Georgia, Atlanta, Georgia. Also with us, Gabriel Sepulveda-Sanchez, trial attorney in Los Angeles, and Vic Bajaj, criminal defense attorney in San Diego. So we're locked and loaded tonight. You all have a lot of experience, understand this. Marsha, let me begin with you. You're in Georgia. Felony murder. Explain to the folks at home who haven't been down to Georgia how prosecutors use felony murder, what it means to a criminal defendant who's been charged with it.
Well, felony murder means that you have been charged with a murder charge. That means you have an underlying felony that you're in the commission of. So the underlying felony in this case is going to be the attempt to commit the false imprisonment that he has been charged with. Felony murder means you are just as culpable because you are participating in the commission of a felony at the time someone died.
So this is serious as it gets. Gabriel, attempted false imprisonment. What do you think that means? And what do they have to show to demonstrate that he attempted to falsely imprison Ahmaud Arbery here?
So attempted false imprisonment means that it's an unlawful restraint against someone's movement. So basically, they have to prove that he unlawfully restrained or confined Ahmaud Arbery to that area there. So, in my understanding of that is it's not a high burden to prove that someone actually committed false imprisonment. As long as they didn't have any justification to confine them to that area, that's pretty much all they need to prove that charge as far as unlawful false imprisonment. That could be as simple as not hit for just to confine them to the area with the car, something of that sort. That we don't know exactly what the facts are as far as we don't know how much involved he was in blocking him in there. Maybe there are some text messages between him and the shooter stating that, hey, you guys go ahead and go to the right side. I'll stay behind him and I'll cut him off. We don't really know what the evidence is on the cell phones, text messages, emails. I don't know how much plotting, how much active participation he had in confining him. So they have to have some sort of evidence.
Gabriel, I'll tell you what his lawyer's saying. His lawyer's saying there was no communication. There was no communication between the McMichaels and Roddie Bryan who's shooting the video. So Vic, it's not even false imprisonment though. It's attempted false imprisonment. So can it be enough that someone's running down the road and you try to cut them off and block them in? Is that an attempted false imprisonment?
I believe what happened is that law enforcement in here had to take the evidence they received, which would be the statements that this individual made to law enforcement without a lawyer present, and come to a conclusion as to whether there was any indicia of a crime. This is under the umbrella of an enormous amount of public pressure to find charges and file these charges against this individual. Attempted false imprisonment, in my mind, that's a thin charge in and of itself. You're right, your previous guest said correctly that it's just trying to prevent the asportation, trying to prevent someone from moving from one side to the other side. I want to go. In domestic violence cases, we see it quite often. I'm going to leave. I'm going to go to my girlfriend or boyfriend. No, you're not. And you stop them from leaving. That's enough for false imprisonment. The thing that's shaky for me as a defense attorney, and of course any prosecutors or former prosecutors can chime in on this, is how do you determine intent? So the statements that this individual made have to be part and parcel to the creation of the mental state of mind. I was going to block him in, or something of that nature. But a very shaky charge to begin with, quite frankly.
Well, they may have videotapes. Let's take a look at a map. Ted Rowlands last night on the program did an incredibly detailed piece about where they were going. And as you watch this map, you can see that there's two vehicles involved. And the question is, did Roddie Bryan impede the progress of Ahmaud Arbery as he's being followed by the two men who've been arrested in the pickup truck? Now, when we pick up the video, obviously he's behind him. So at this point, he's not blocking him. It looks like the McMichaels are blocking him. But did he initially block them? Marcia, do you think that's enough in Georgia that if a man is running, there's a pickup truck behind him, he's running away from it, and then you block the road, and then the man running turns around and starts going the other way or runs around your car? Will that be enough for an attempted false imprisonment? Because that's the road to felony murder in this case.
We all know that it could be enough for a jury, because keep in mind, as co-counsel just said a few moments ago, that if an individual in a similar situation was to say, I'm leaving my home, your spouse says, we're having an argument, I'm leaving my home, and she tries to get in her car and you block the driveway, you can be charged with, attempting to commit false imprisonment. So I don't believe it's a weak charge. As a former prosecutor, I'm telling you, I've seen jurors convict for that. And it doesn't necessarily have to be that you physically touch the person, but you're also preventing the person from being able to leave the area for some reason.
So I got to think they've got video of him doing that, because I don't think he admitted doing that, and the other defendant said he did it. What's that?
There's got to be some of those home video cameras that was there monitoring homes, or doorbell cameras. And what individuals are forgetting is that law enforcement investigating this may also have cell phone records, either text messages between the parties or phone calls to that individual. In fact, when Mr. Bryan's attorney spoke on television previously, he spoke about him being at home minding his own business, and then all of a sudden he's at the scene videotaping and chasing a suspect.
Yeah, and again, I'll say it because he said it to us that there was no communication between the McMichaels and Roddie Bryan, but we'll see what the evidence shows us. Lee Merritt represents the family of Ahmaud Arbery, and he spoke to us before this arrest came down late tonight. Let's take a listen.
William Bryan, also known as Roddie, we know obviously he was there because he admits that he took the video. We know that he was in his truck and that he was traveling around following Ahmaud, again, from his attorney's statements. Now, there was some ambiguity early on from my office and from other investigators as to how he became involved in the case, but his attorney began at least to offer his explanation, which was he was sitting at home, and all his attorney tells us is within minutes he was behind Ahmaud Arbery recording him. So we know that he left his home, we know that he got in his truck, and we know that he joined this pursuit. Now, his co-conspirator, Gregory McMichael, has said that he actively participated in trying to box Ahmaud Arbery in, that he was unsuccessful at first, and then we saw at in the video itself that eventually he was successful, blocking his point of exit when forcing Ahmaud Arbery to come into the confrontation with the McMichaels. Those facts actually aren't in dispute. The only thing really that seems to be in dispute is what that means or whether or not that was criminal. And from my perspective and from our experts, that's clearly playing a key role in this event, and Mr. Bryant will likely have to face criminal charges and prosecution as well. I think that's going to be up to the district attorney and the grand jury. I can say that when someone is murdered and other people participated in, although they may not be the trigger man, a common charge that we see is felony murder, that you participated in this event that caused the death of another human being, and so you will be charged with their murder as well.
And he was. Roddie Bryan now charged with felony murder. Gabriel, let me ask you, do you think our system of justice should treat the two guys in the pickup with the guns the same as the guy in the other vehicle with the cell phone.
Yes, he was an active participant. Based on, people have to remember that intent can be shown through circumstantial evidence. There's a reason they brought these charges against the person taking the video, and one of those things they're going to ask too is why was he filming this thing? Did he even call 911 prior to filming this, or was he just, he saw a person getting shot? Why didn't he call 911? All these things, there are people forgetting that there's circumstantial evidence that can show intent, and I think that's why the prosecutors feel confident in bringing this case, is because it's not just the fact that he was following around the two perpetrators that shot Ahmaud Arbery. It's the fact that, why didn't he call 911? Why was he filming this thing? Why didn't he do anything to intervene? All these things in conjunction with the following of Ahmaud and the videotaping, maybe not not calling 911. There's a reason these charges are brought in. If they can show that he was aided and abetted into this situation, was an active participant, and wasn't just a witness to the shooting. If they can show that he wasn't just a witness, they have a case. And this guy should go down just like everyone else. That's my opinion.
Vic, he voluntarily gave police the video and told police about the video. I don't think anyone in the world other than Roddie Bryan at the time of the shooting knew there was a video of everything that happened. Does he get any credit for that? Because right now it doesn't look like prosecutors are impressed at all with him voluntarily showing police officers at the scene the video of the shooting.
Well, the credit he gets is being charged with felony murder. I mean, this is a textbook scenario on why you don't make statements when prosecutors and law enforcement officers are looking for evidence and trying to solve a murder case as to whether something was self-defense or not. There's no mystery in this case that he knew these individuals. He lived in the same area. He even made statements that were leaked saying that he recognized the truck but did not recognize the individual jogging. I mean, these are damning statements. These are statements that lead one to believe that the indicia of his knowledge is much greater than his defense attorney ended up saying afterwards. And I have to give a little bit of pushback in regards to our other guest tonight, in regards to the attempted false imprisonment being a non-shaky or a strong charge. I disagree. If you're going to charge somebody with attempted false imprisonment, charge them with attempted false imprisonment. The nexus here is that it wasn't only attempted false imprisonment, but it was also attempted false imprisonment, which led to the death. And so that's why it's a shaky case. I don't think he's going to get any credit at all for producing this video, which is extraordinarily damaging to his case and the co-defendants. And I think if it does anything, it will not provide corroboration for the innocence-seeking statements that he probably tried to give to law enforcement. It's very important to understand this case as an example. We do not encourage people to head on in to make statements in an open investigation without open dialogue with prosecutorial agents in the case. It can prove to be disastrous, as we can see here. So to answer your question, Vinny, which is a great one, I can't see him getting any credit for coming forward with that video.
Who knows why he gave that
Now,
video?
not only spoke. Go ahead.
No, who knows why he gave that video? People do stupid things. He might have given that video to law enforcement to try to, get himself out of the situation. Oh, here's this video I saw. We don't really that's given too much weight, I think, right now. And who knows what his intent was? But people do dumb things like that, and he could have given that evidence over to law enforcement to, remove himself of the situation when he really was involved. That's right.
That's a good point. But importantly, he wasn't the one who produced the video. It wasn't sort of a situation where he gave it to law enforcement. As I understand the factual scenario here, a lawyer provided this video. A lawyer leaked the video to the press, and it was only a couple of 3 days after.
But his story, Vic, his story is that at the scene, he showed the video to officers. It was subsequently made public through the lawyer, but Roddie Bryan and his attorney saying, no, at the scene, I invited the police into my car and showed them the video on my cell phone at the scene that day. Roddie Bryan also spoke out not just to police, but he also spoke to Chris Cuomo on CNN. Take a listen.
I would just like to say, first of all, I am very sorry to the family. I pray for them every night, as well as my own family.
Marcia, your thoughts about Roddie's prayers for the family?
It's a sad situation because a lot of times I've seen defendants, and I do defense work, and I've seen defendants believe that I am gathering evidence and what they believe to be evidence to prove their innocence or to exonerate them is actually evidence that digs them deeper into the offense that they're being charged of. I don't believe when Roddie was making this video that he thought he was preparing evidence to show that he was assisting with the commission of a felony. I think he actually thought, I'm showing this young man who we suspect of committing a crime, and I'm helping with completing a citizen's arrest. Unfortunately, ignorance of the law is no excuse. So that's where he's found himself in a situation where I'm recording this because I think I'm protecting myself, and I'm going to show it to law enforcement. And it's going to prove exactly what I wanted to prove, that we got the bad guy and we took him out. And they're going to be happy and they're going to thank me for it.
There's a lot of entitlement.
And by the way,
there.
if he's attempting an unlawful arrest, he's guilty. We've got to get to our next story. Next story, Lori Loughlin, when we come back, also known as Aunt Becky from Full House. You know, she's all caught up in the college admission scandal, and her attorneys were fighting it tooth and nail, trying to get it dismissed. Well, guess what? A deal has been struck. The details next. Major developments tonight in the college admissions scandals case. Ted Rowlands takes a look at Lori Loughlin, who now has decided to take a deal.
We're here today to announce charges in the largest college admissions scam ever prosecuted by the Department of Justice.
14 months after their arrest, actress Lori Loughlin and her husband, designer Massimo Giannulli, have agreed to plead guilty and go to prison for their role in the college bribery scandal. The plea agreement, which is expected to be approved by the judge, will send Loughlin to prison for 2 months with a fine of $150,000. Giannulli will spend 5 months in prison and be fined $250,000. Prosecutors allege that Loughlin and Giannulli paid $500,000 to get daughters Olivia Jade and Isabella into USC. The plan, orchestrated by mastermind turned FBI informant Rick Singer, was to pretend the girls were accomplished rowers. These photos of the girls on rowing machines were part of the government's case. In a statement released this morning by the Department of Justice, U.S. Attorney Andrew Lelling said, under the plea agreements filed today, these defendants will serve prison terms reflecting their respective roles in a conspiracy to corrupt the college admission process and which are consistent with prior sentences in this case. We will continue to pursue accountability for undermining the integrity for college admissions. Loughlin and Giannulli were 2 of 50 people arrested last year in what was named Operation Varsity Blues. They are the 23rd and 24th parents to plead guilty, joining fellow actress Felicity Huffman, who served 11 days in a Northern California prison.
My advice is to recognize in the totality of her life, 2 months inside of a minimum security camp is a blip.
Author and prison coach Justin Paperny is a former stockbroker who spent 18 months in federal prison. He says both Loughlin and Giannulli need to keep their heads down and try to use their time behind bars to be productive.
So he has a wonderful opportunity in front of him to make this 5 months or 2 months for Lori a productive time, or it can be a miserable time where their sentence feels like, 10 or 15 years. She could be a target, look to get exploited by some of these prisoners who may be jealous of her success, her fame, her wealth, the brevity of her federal prison sentence. So it's in her interest to understand how others will perceive her, to lay low, to understand her environment.
Paperny also discounts the notion that minimum security prisons are country clubs.
The reality is you're confined. You're told with whom you have to share space, what type of job, how many phone minutes a month. You can get sent to the whole or a higher security prison if you get into trouble or associate with the wrong people. So it makes for good headlines at country club. Though having endured it, I can tell you there are very few similarities between life in federal prison and life in or being a member of a country club.
Loughlin and Giannulli are scheduled to plead guilty tomorrow. A sentencing date is expected to be set during the couple's appearance.
2 months. She was facing 50 years. I mean, it's obvious to me that the government did not want to try this case. They folded. I mean, she got a better deal now than she would have gotten if she had pled early on in this case. Let's bring back in our think tank. Vic, do you agree with me that the government folded on this one? They didn't want to try this case.
Absolutely. I couldn't agree with you more. You hit the nail on the head. I mean, let's look at what the government let out there in the public and all the public statements that were made. They said very clearly that, she is a poster child of someone who should have accepted responsibility. And the media was very clear about something, which is she's going to be made an example of. Now, of course, she hasn't had the plea accepted by the court, and the court has its own tilt and perhaps impression of her denying initial responsibility. But this is in the category of her defense attorneys doing an excellent job. Perhaps there was an issue with the evidence. Perhaps there was some illegally obtained evidence, or there was some marks upon some percipient witnesses who were going to testify against her and her husband. But at the end of the day, you hit the nail on the head again, Vinny, that you're absolutely right. In my book, this is the prosecutor saying, give me that symbolic conviction. Let's agree to something so we don't have to air out our dirty laundry. This is a prison sentence that I think we can all agree to, and they did fold. That's exactly what happened.
Yeah, Gabriel, she got a better deal now than she would have gotten if she pled initially when there were less charges against her. This is amazing.
Yes, sometimes in my experience too, I've seen that as a defense attorney, if you're bringing that case on, you're dragging it out. Sometimes there's just fatigue on the state side too. The prosecutors just, we got other cases going on, COVID-19, courts are shut down, limited resources, all these problems are going on right now. And it might have been just the perfect timing for the defense attorney to just make this deal, and things might have just lined up for her. I think she got off easy on this. And, right now courts in California are limited resources. We're shut down. They're having emergency hearings only. There's so much limited resources and so much stuff going on in the court systems right now that this could have just been a good timing for her and her defense lawyer to make this deal.
Marcia, are we going to hear some arguments that maybe we should do home confinement with the COVID-19 problem?
You probably are going to hear those arguments, but I think this deal would have been on the table had she not been a celebrity at the beginning of this case. A lot of times when there's a lot of media attention associated with a case, you want to make an example out of someone is a celebrity, and individuals are upset because they use their celebrity status. The sad part about it is that $500,000, she could have bought a wing and her kids would have still gotten into the school. So I don't even understand why they chose this route as far as getting the girls into a university. They could have done with the same amount of money, maybe even less. But COVID-19 is not going to keep her out of prison because her celebrity status is going to force the courts to have to show that when you're wealthy, you get treated just the same as individuals who are not wealthy.
Yeah, and Marcia, that is so true. That really, the real dirty laundry here was the way these colleges, and they talked about the integrity of the college admissions process. It's anything but filled with integrity. But that's another issue for another day. I could spend hours talking about it. All right, when we come back, we're going to talk about another case out of Massachusetts. This guy's a world-renowned doctor and a former Olympian. I mean, he's smart, athletic, he's got everything. But now he's in jail, charged with the murder of his wife. That story next.
Welcome back to Court TV Live. I'm Julia Janae. With your Court TV news break, we begin with breaking news out of Louisville, Kentucky, where we've been following closely the officer-involved shooting death of EMT worker Breonna Taylor. This just in, the chief of police in Louisville there, Steve Conrad, has announced his retirement after 40 years on the force. Family attorney Ben Crump released a statement calling Conrad's resignation a, quote, significant step forward in getting justice for Breonna, her family, and the city, but also said it's just the beginning. The 26-year-old Kentucky woman was fatally shot by officers last month during a no-knock warrant search on her home for drugs. Police say the shooting started in response to Taylor's boyfriend firing his weapon. No drugs were found in the home. And the FBI and Kentucky Attorney General have announced that they are also now investigating that case. And the Colorado stepmom accused of killing her 11-year-old stepson is making new requests to a judge. Letitia Stauch's attorneys say they can't get ready for the upcoming preliminary hearing because video visitation at the jail has been cut off due to COVID-19 restrictions. In a motion filed in the case, the defense demands Stauch be provided her own private video access or be released on bond. She's currently there on no bond. Stauch faces a first-degree murder charge in the death of Gannon Stauch. He was missing for months before his body was located in Florida back in March. Her attorneys are also asking for a continuance to the upcoming June 5th hearing. And over 1,000 pastors plan to go forward with church services defying the California governor's stay-at-home order. This is according to an attorney representing the faith institutions. Governor Gavin Newsom is relaxing restrictions and letting some businesses reopen, but churches are still banned. The Justice Department's Civil Rights Division has warned the governor that this move discriminates against places of worship. Newsom maintains that church services will be allowed to resume in the coming weeks, and the goal is to protect public health. But on May 31st, a group of 1,200 pastors have signed a letter saying they plan to congregate with or without permission on May 31st. That's it for your Court TV News Break. Vinny, back to you.
I smell another lawsuit or court appearance, something, and we'll see how it all turns out. Julia, thank you so much. You know, I've covered hundreds of trials through the years, and there's a handful that I remember so vividly. One of them was involving a doctor named Dirk Greinider up in Dedham, Massachusetts, who was accused and then convicted of murdering his wife. Now, 20 years later, because that was like 20 years ago, 20 years later, there's another high-profile doctor in Dedham, Massachusetts, in the courtroom there, who's going to be charged and perhaps tried for murder. Julie Grant has the details.
Robotic-assisted surgery made him famous, but murder charges may make him infamous. Dr. Ingolf Turk was once head of urology at St. Elizabeth's Hospital in Brighton, Massachusetts.
Dr. Ingolf Turk is not your typical surgeon.
This promotional video from 2009 was made by St. E's parent company, Steward Healthcare.
At 6'3" with an athletic physique, it's easy to see why he was once a member of the German Olympic decathlon team.
It showcases the doctor's well-roundedness, his skill in robotic surgery, and its benefits. Fast forward to 2020, that pristine picture has drastically changed. Stewart fired the doctor in February after a scandal involving fraudulent billing. 3 months later, he's behind bars without bond for allegedly killing his wife, Katie McLean. According to police, it was McLean's ex-husband that alerted them on May 15th that she was missing. That day, police found Turk unresponsive at a nearby Residence Inn. He was revived with Narcan. Officers observing lacerations on his forehead and wrist, cuts on his arms and legs, consistent with walking through brush. The next day, police say Turk confessed to strangling McLean during a heated argument while they were drinking, claiming McLean hit him over the head with an object and he started choking her. Realizing McLean was dead, the doctor reportedly told police he panicked, dumping her body in a nearby pond. According to police and court records, the May 15th incident doesn't appear to be isolated. On December 7th, 2019, McLean alleges she thought she was going to die when Turk choked her and slammed her into their headboard. 1 week later, the couple married in Las Vegas. Then on January 11th, McLean alleges more violence, saying Turk threw her to the ground after asking if she was cheating. A few weeks later, she filed for an abuse prevention order and reported it being violated on February 5th, prompting police to charge Turk. Then on May 2nd, McLean went to court and asked that her civil abuse prevention order be vacated. She asked prosecutors to drop the criminal case as well, but they didn't, and the judge wouldn't adjust Turk's bail conditions to allow him back into the home. But Turk went anyway. Now, all those past allegations may become an integral part of the state's murder case if they attempt to establish a pattern of domestic violence being carried out by the once highly regarded surgeon.
You know, a trial should be the search for the truth. And you know, we have rules of evidence that prevent certain things from coming in front of a jury when they have to decide a case. But a case like this, it just seems like the jury should know about this domestic violence. I mean, walks like a duck, quacks like a duck, right? Let's bring back in our think tank. They may or may not agree with me. I'm not sure. Marcia, I mean, is there any reason in the world why the jury shouldn't know about a history of domestic violence in a murder case where a husband's accused of murdering his wife?
Well, it sounds based on the facts that this might be a temporary insanity defense that's going to go forward as it pertains to we were both drinking, we got so drunk and got into a heated argument, and she is really the aggressor this time in the argument. If I go with my prosecutorial experience, it would be yes, let it in so the jurors can see that there's a history. However, the law sometimes prevents such evidence because propensity evidence is not admissible. It's going to have to be relevant to the facts and circumstances surrounding the day of this actual murder. And that's where the problem comes in. As defense counsel, my goal would want to be, hey, let's keep this out at all costs, because your concern is that the jurors are going to convict this defendant, not based on the facts and circumstances associated with the homicide case, but based on incidents that occurred between the parties years ago.
Vic, if we do that, though, aren't we putting blinders on the jury and they're not getting the truth of what that relationship was about and what was happening? I mean, to me, there is absolutely probative value to know that this guy wasn't a domestic abuser.
Absolutely. There is probative value, Vinny, but your guest is absolutely correct. We have to balance that against the prejudicial effect that evidence may have against the charged defendant. In this case, one would ask, well, what trial? I mean, here we have an individual, the doctor has taken law enforcement out to the body, has lined up pretty either truthfully or in a premeditated fashion, a reduced mental state defense, whether that will be temporary insanity, a heat of passion, or something of that nature. It sounds like it would be a very, very hard hill to climb forward on or up towards if you're going to say it's going to go in front of a jury. But the recency of this issue is tremendous. The recency of the claims of domestic violence are tremendous as far as their impact goes. And I would be hard-pressed to believe that any juror would not be able to hear that information if it were to be able to proceed to trial. A judge, I believe, would let it in.
You know, Gabriel, I've never seen in my years a doctor who's going to admit to murder. I just don't think it's going to happen. This guy was an Olympic athlete. He's competitive. He wants to win. I don't see him throwing in the towel, even if the confession comes in.
Yeah, a lot of those personalities too. Some of these guys have enormous egos and they're narcissists, and he may feel confident. Like you said, he has that A-type personality where he thinks he can win everything and he's willing to put it all on the line. So that could be a situation. He's got a successful career. He's probably a high net worth individual. It's gonna be whether he wants to take that chance and go to trial. And it wouldn't be surprising based on his personality and what you just shared with me that he wants to take that chance. You just never know. He could be like, hey, am I gonna spend 20 years in prison? The rest of my, am I gonna spend the remaining days of my life in prison or potentially get off on this? So I might as well take the shot and do what I can. So it doesn't surprise me with these types of personalities. He might take that chance.
When we come back, doomsday cult mom Lori Vallow Daybell, her husband Charles, on video 6 months before her brother shoots and kills him, revealing a lot about Lori Vallow and a lot about Charles Vallow, and perhaps a lot about the missing children, JJ and Tyler. Your reaction next.
She's lost her mind. I don't know how else to say it. We're LDS. She thinks she's a resurrected being and a god and member of the 144,000.
Video that came out proves every statement we have made that Charles was an extremely unique person.
Psychologically, she's gone. Something's happened to her.
How old is she?
45.
45. She said that she would murder you through a spiritual...
No, she said, I can murder you.
I can murder you. And she's talking in a
I will kill you.
Spiritual.
No, she's talking physically. I will kill you because you're not Charles, and nobody will care.
Okay. So she at this point doesn't think you are her husband?
She thinks I'm Mick Schneider.
Who's Mick Schneider?
I have no idea.
And I knew that some of the statements being put out about him were totally false. And that video right there proves everything that I've said, everything that I've thought.
That's Larry and Kay Woodcock, little JJ's grandparents and relatives of Charles Vallow, commenting on that video of Charles Vallow. That's Lori Vallow's fourth husband, shot and killed by her brother. But that's 6 months before that happens, really revealing a lot about Lori Vallow and what was going on in her head. That was their reaction. I've got your reaction tonight from social media, 13th juror. And our comment of the day tonight comes from Nancy, who says, frightening and overwhelmingly sad. Charles seemed like a kind and tolerant man. She must be mentally ill, but the fact that she won't say where her children are is unbelievable. I really don't want to think they're not alive. This is so very sad and heartbreaking. Vic, let me ask you something here. There's no insanity defense in Idaho, but if in fact her attorney believes that she's mentally ill, I mean, what do you do with that? What do you do with that if your client is mentally ill and there's no insanity defense where she's going on trial?
Well, you may not have an insanity defense, but you have a competency issue, and you would be hard-pressed to believe that their attorneys would not explore that issue. And this is really an examination of the defendant and whether the defendant understands the process and the proceedings against her in this case, and who the roles are filled by, who's the judge, who's the defense attorney, and who's the prosecutor. So you're absolutely correct that the jurisdiction does not allow for a mental insanity defense, but her competency, given the excerpt that our viewers just saw, would be in play and a very important tool to use.
Yachty writes tonight, that Lori Vallow Daybell is a sick puppy. It seems she does everything out of spite. She's all about herself. She doesn't care about anyone. Her husbands didn't mean anything, and certainly not her children. If she can't benefit by something or someone, then they become disposable to her. Lori needs her head examined, which may very well happen. Gabriel, who is this woman? Is she someone who truly believes that the world is ending on July 22nd? Just want to mark your calendars. Or is she someone who's just a bitter divorcee and doesn't care about anyone but herself?
I think she's playing everyone. I've seen some other video clips of her making statements to officers, and she appears lucid and competent in those statements. She could be acting like she's crazy in certain situations and then just being competent in other situations. And I think that's just her maybe her way of trying to get away with murder here. So I think she knows exactly what she's doing. I think she knows the nature of her actions, and I don't think she's insane at all. I think she's playing the system and acting like she is with her husband, and then acting like she's not. She's okay with acting like she's competent with other people. So I think she's just playing the game. I don't think she's sick at all.
Lisa tonight, not making sense to me why the officer on the scene didn't do a missing persons report that night. Safety of the children, death threats to him, Lori's bizarre behavior was too much to just be ignored. Charles needed the help through the courts to get Lori a clearly needed psych evaluation and some kind of safety plan in place for him and his kids. Even though the officer was polite, I'm sorry, he didn't take this whole situation as seriously as it was. And obviously, Marcia, he didn't know what was going to happen over the course of the following year. But this is a case where the kids are gone, the car is gone, he's locked out of his own house. Is there anything police could have done there?
It's tough. Those situations are tough. Even in situations where someone is not lucid and they're making comments that you think might be causing them to be a threat to themselves or to others, without court intervention, a lot of times when law enforcement shows up and the person is not exemplifying any type of criminal conduct, there's not much they can do. Their hands are tied sometimes. So it's sad to say, but we live in a society sometimes as it pertains to the law where things almost have to go bad before law enforcement who shows up to the scene, such as a scene like that, can do anything about it, like taking anybody into custody or taking her to have a mental evaluation. That's very, very uncommon that they would have that type of authority.
All right, we're going to give Tina the last word tonight. This poor guy was afraid for his and the children's life, and rightfully so. It's apparent she has a severe mental health issue that she didn't get help for. Now he is dead, and sadly the children are most likely as well. Those closest to her should hang their heads in shame for not trying to get her help. Would like to thank Marsha Mignon, Gabriel Sepulveda-Sanchez, and Vic Bujaj for joining us tonight. Great job. Great to have you on the program. Stay safe out there. And everyone else, we will be back tomorrow from 8 to 11 live here on Court TV. Have a great night. And from a distance, don't forget to hug the kids.